Hello, everybody. This is Howard Wasserman, who is been given the very special opportunity to speak to all of you about treaty-based filings. Just to give you a quick update about myself, I speak often for AJAG. I am a tax partner at a firm called Siegel LLP, and I've been doing so for over 30 years, shockingly. I deal with owner-managed businesses as well as those that have to deal with cross-border issues. And one of the issues that I've seen many, many times where there's been some confusion and uncertainty is when a corporation has to file a Canadian tax return and the nature of that filing. So my presentation today is going to focus on treaty-based filings, and we will address some of the issues that you need to consider when you have a foreign company who has any kind of activity in Canada. So, as a general rule, the big issue to decide is when is a non-resident corporation taxable in Canada. And generally speaking, if that non-resident corporation is carrying on a business in Canada, then that company is subject to Canadian taxation. But what is this notion of carrying on a business, and is it a defined term? And it actually is. It's in Section 253 of the Income Tax Act, and it says that it is not limited to the following. So it's giving a very broad definition. So the first thing is a company that solicits orders in Canada. And more importantly, the one that will get most people caught is offers anything for sale in Canada through an agent or a servant. So an agent means an arm's length entity. A servant, which is a terrible word, means an employee of some sort. And this applies whether the contract is completed inside or outside of Canada. So dropping off goods in the United States and having them, then shipped over to Canada is the same as delivering the goods directly to Canada. And it also includes anyone who produces, grows, mines, creates, manufactures, fabricates, improves, etc., anything in Canada. So really what this law says is that any kind of activity in Canada, any kind of sales activity, especially in Canada, would be considered carrying on a business. And there's no threshold. Like, it doesn't say if you're selling over $100,000, if you're selling over $1 million. It is any activity where there are sales in Canada. As a starting point, that means that you are now taxable in Canada on that activity unless there is a treaty. And where the treaty applies, and there's 84 countries, quite a lot of entities, the test for whether you are taxable in Canada shifts from whether you are carrying on a business in Canada to whether you have a permanent establishment in Canada. And if there is a permanent establishment in Canada, then the taxation in Canada is on the profits related to that permanent establishment. So if you have a company that has significant sales around the world, from a treaty-based perspective, the permanent establishment in Canada will do its own income statement. And that permanent establishment in Canada will be the revenue from Canada only and the expenses related to the operations of carrying on that business in Canada. And that that determination of expenses will include direct expenses, such as, rent maybe, or other things that happen in Canada. And there is the ability to allocate a portion of, let's say, head office or other expenses if they are directly related to the operations in Canada. So that is a little bit subjective, but something to be aware of. So what is this permanent establishment? As per the Canada-US Treaty, it includes a place of management, a branch, an office, a factory, a workshop, and then basically mining and other kinds of activity. So the way that I like to, big picture, start off to define a permanent establishment is, can you knock on a door and the name of the company is above that door? So the very common question I get is, what about an employee working in their basement in Toronto, for example? So my question would be, if I went to that person's house, is there a sign out front that says, ABC company? Another question, if I looked on the website of the company, does it say that the Canadian operation is at this address, the person's address? What does that person's card say? Again, all of these are indications that there's something more permanent. If it's an employee who is doing administrative work, let's say, and works out of their basement, likely that is not a permanent establishment. So there's an expanded definition of a permanent establishment. It also includes a building site or construction or installation project if it lasts more than 12 months. So that's important because, what if something was bought down in the States and the project takes a very long time? That U.S. company now has a permanent establishment in Canada. And it also includes situation where contracts are concluded by an employee in the country. And it does not include contracts concluded by an arm's length party. Now, this is also a very, very important thing to understand. If an American company sends its employee to its Canadian customers, and the U.S. employee and the Canadian customer have a coffee together, and they sign a sales agreement on the spot, the U.S. company has a permanent establishment. If the U.S. company has a Canadian administrative employee, and that administrative employee goes and meets with with Canadian customers, and again signs a contract, you again have a permanent establishment. So it is very important, if the U.S. company does not want to have a permanent establishment and does not have one otherwise, that they should not have one of their staff signing contracts in Canada. Instead, that same employee, whether it's a Canadian employee or a U.S. employee, can go meet with the Canadian customer, can negotiate the deals, but there should always be a requirement that the sales contract is sent back to the United States and is signed off by an American employee, not an employee in Canada. If that is done, then you go from having a Canadian permanent establishment to not having a Canadian permanent establishment. So let's look at a few other extended situations. What if there are services provided? You have a permanent establishment where there are services provided and the individual has been in Canada for 183 days during any 12-month period that begins or ends in the year. And the service revenue during this time is more than 50% of the active business revenue for that period. So let me give you an example. Let's say the total revenue for the year is $100,000 for a non-resident company, and the revenue derived from providing services in Canada is $60,000 from an employee that was in Canada for more than 183 days. That is a permanent establishment. So you're looking at situations, especially where you have a consulting company where it's, maybe a small group, 1 or 2 people, and one of those people is in Canada for a significant period of time. You may think you don't have a permanent establishment because there's no office here. But you have to remember, if a staff member is in Canada for more than 183 days, you then need to go to the next level and say, what is the revenue earned in Canada relative to the revenue for the entire period? Okay. Okay, let's look at another special situation. Here's another situation where you have a permanent establishment. In this case, the services were provided, again, for 183 days within a 12-month period, on the same project for customers who are resident of Canada and have a PE in Canada, and the services are provided in respect to the PE in Canada. So to give you an example, an American company sends somebody on a large project, and they're here for a long time, and they're servicing a Canadian customer. Again, that is not an overly complicated situation. And even though the U.S. company does not have an office in Canada, you have to remember that once a staff member has been in Canada for more than 183 days on one project, the U.S. company likely or for sure will then have a permanent establishment. Really, the key is to highlight the issue so you know that if ever there is more than 183 days that an employee's been here, you have to dig a little deeper to determine if there is a permanent establishment. If that employee is here on different projects and for different customers, it's not the same thing. This is one project for one customer and 183 days. So what is not included in a permanent establishment? Well, it doesn't include facilities for storage, display, or delivery, keeping inventory for process by someone else, just the act of purchasing goods or merchandise, as well as advertising, supply of info, and R&D. So how's that relevant? It's entirely possible for a U.S. company to buy a warehouse in Canada and not have a permanent establishment if the only point of that warehouse is to store inventory. But, and this is where people often run into problem, what if you have a warehouse and 90% of it is used to store inventory and the front has an office and is used by admin staff? Now you have a PE. Now you have a permanent establishment. If the facility is just for storage or display, so let's say you're a window manufacturer and people want to see the windows, so they come to this location, they see the windows, they love them, they want to buy them. That does not give you a permanent establishment, provided the customer makes the order to the United States, and again, the sales agreement is consummated in the United States and not in Canada. Okay? Now, if at the end of the day we have decided that it is a permanent establishment, well, what do we have to file in Canada? So if a foreign company does have a permanent establishment in Canada, then they have to file a Canadian tax return, just like every other Canadian resident taxpayer. And you also might have to file a T-106, which is a big deal when you're dealing with transfer pricing issues. So if it is determined that a company has a permanent establishment, then the issue of transfer pricing becomes far more relevant because you might have to file the T106 if the activity with non-residents is greater than $1 million. The other thing to be aware of is if you are carrying on a business but don't have a permanent establishment, there still is the requirement to file a Canadian tax return. And this is what's called a treaty-based disclosure. And on this tax return, essentially you fill out a jacket. You do not have to send an income statement, but you do have to complete Schedules 91 and 97. And I'll go into a little more detail in a minute, but you do have to fill out those forms, and you do need a business number because you can't file a corporate tax return if you don't have a business number. So you will need to file the RC1 to get a business number. So let's go a little deeper on those two schedules. So if you are filling out Schedule 91, be very careful or be aware of the question about salaries in Canada. Because if the foreign company was paying salaries in Canada, whether it's to a Canadian employee or a U.S. employee, there's the issue of appropriate withholding taxes. We see this all the time. A U.S. employee comes to Canada, is here long enough that there should have been withholding taxes and there weren't. And, you have to answer the question truthfully. And it's very straightforward for CRA to say, hey, this company paid salaries. There's no T4, there's no NR4, there's no withholding taxes. Where is it? The other thing to be aware of is subcontractors. So the question is, did you hire any subcontractors? And if the subcontractors did the work in Canada, then there should have been withholding tax, generally 15%, on that work. So even if, this is only for foreign subcontractors. So it's not uncommon for a U.S. company to hire a U.S. subcontractor who knows the business, and they bring them with, essentially. And if they do that, there should have been 15% withholding tax on the work done in Canada. It does not apply to Canadian subcontractors because they will just report their tax as they should. In switching to Schedule 97, here you have to say the nature of the reason you're filing a tax return. And the most common will be treaty-based corporation, which is number one. But be very aware of LLCs. LLCs are considered corporations in Canada, but they are flow-through in the U.S. And in some cases, they do not get treaty protection. It really all depends who the ultimate shareholders are. So if a foreigner in a non-treaty country is a shareholder of an LLC, that LLC will not get treaty protection. If alternatively, it's a individual in a non-treaty country who owns a C Corp, that C Corp gets treaty protection. Doesn't matter who the shareholder is. So there is a form called an NR 303 that will often determine the benefits under the treaty. Okay? So one thing I want to stress again, if you do have clients that sell anything into the US, into Canada, there is a requirement to file these forms. If you don't, you are subject to penalties, and I believe the penalty is $2,500 per year. You also risk not being able to properly calculate taxes. CRA could calculate taxes based on sales instead of on profit. So if there is a treaty-based reason why you don't have to file a tax return, and you've gone through the analysis of whether there is a permanent establishment or not, I really don't think U.S. businesses should be afraid to file these forms. The other thing I should mention, I am not an HST expert, though we do have them in the firm. You may have a client that should be registered for HST, even though they don't have a permanent establishment in Canada. The threshold for HST and GST registration is lower than the test for permanent establishment. So you may have a situation where the company is not taxable in Canada on an income tax basis, but maybe should be registered for HST and collecting HST and remitting to CRA. And for a non-resident client, this is especially attractive if they have Canadian expenses, because if they are registered, they do get the HST back. And with that, I will conclude my comments on treaty-based filings, and I wish all of you a wonderful, wonderful day.